Good morning, Mr. Rao.
Good morning, sir. Good morning, sir.
Yes, yes.
Neeraj,
मैं Zoom मीटिंग पे हूँ।
Joseph, sir. Good morning.
Hello.
Good morning.
Mr. Rao, am I audible? Hello.
Yes, sir. Very loud and clear, sir.
Okay. Neeraj had called us now that his light has gone off there.
Somebody must be harassing him, sir.
Right, MHADA people.
Yeah. They should do it at my place, sir.
At your place. Okay.
Correct.
Then fortunately he had made me the co-host, otherwise this would have gone off. If there was no other host, we wouldn't have been able to do the this thing. What do you say? Webinar.
Yeah. No issues, sir.
Amit ji has come. Amit Israni ji. Joseph, just check.
खाली करने का तो ये लेके आई।
Sir, I think Amit sir has a slight medical issue. He's got some dentures work done, implant. So he has a slight problem talking, I believe.
Okay.
So we may not be able to use much of his knowledge today.
Let me see how to make everyone mute.
So that is what we've been trying to do for so long, Gaurav sir, to get all the...
हेलो
Yes.
हेलो, आप सुन रहे हैं? मेरा नाम शाहनवाज जी।
हाँ, मैं सुन रहा हूँ
जी। एक्चुअल वो मुझे भी कुछ है ना गाइडेंस चाहिए था। अभी हम लोग बहुत हरासमेंट हो रहा है हमारा।
हेलो।
हम बैठ के बात करेंगे सर, ऐसे कोई प्रॉब्लम नहीं है।
अभी कल वो हमारी बिल्डिंग डेमोलिश कर रहे, कल हमको वेकेंट कराने आ रहे।
लेकिन रेंट एग्रीमेंट है क्या?
नहीं, एक्चुअली कैसा है, ये हमारी बिल्डिंग का टाइटल का इशू है ऑलरेडी।
एक मिनट शाहनवाज सर, मैं आपसे रिक्वेस्ट करूं, आप मेरे को ये प्रोग्राम के बाद फोन करेंगे?
जरूर जरूर। देखिए मिस्टर परवेज कापड़िया भी है, उन्होंने भी, ये भी हमारे टेनेंट है, वो भी एडवोकेट परवेज कापड़िया, ही हैज आल्सो जॉइंड नाउ, ही इज
या
आल्सो
आई
इन
नो,
दिस
आई
ग्रुप
कैन
नाउ।
सी सर। देखो सर,
यस
मैं
यस।
एक तो मैं एडवोकेट नहीं हूँ,
जी जी, यस यस।
okay, but I am very interested in law and the interpretations of law.
Okay, yes, good.
Okay, so based on that, I have now, thanks to Mr. Joseph sir, I can talk on this subject because he has made me get involved in this 90A process, 95A process.
Okay, okay.
And based on that, we have filed some criminal cases.
Okay.
Okay,
sir.
so which I will be discussing during the course. So इसलिए मैं चाहता हूँ कि एक प्रोग्राम होने के बाद,
Yes.
देखो, whether there is a question of title or no.
No, actually just I am giving you the details from base. Start से मैं आपको कुछ मतलब explanation देना चाहता हूँ।
अगर टाइटल ही नहीं है तो आपने डेवलपमेंट एग्रीमेंट कैसे बनाया?
वो एक्चुअल परवेज भाई, आप सुन रहे हैं परवेज भाई? मिस्टर परवेज
भाई, नहीं शाहनवाज जी, परवेज भाई म्यूट है, मैं वही बोल रहा हूँ। लेट्स नॉट, मैं ये प्रोग्राम के बाद बात करते हैं ना सर।
अच्छा, कहना कांटेक्ट किस तरीके से मैं आपको कांटेक्ट करूंगा?
हाँ प्लीज प्लीज आप कांटेक्ट कीजिए। नो,
आपका नंबर वगैरह हो तो मेरे को आप दे दीजिए ना।
हाँ जी,
नंबर दे सकते सर?
97,
जस्ट वेट, आई विल कॉल। यू आर इन बॉम्बे?
यस, आई मीन थाना सर।
ओके।
तो आप उसको बॉम्बे मानोगे कि नहीं मेरे को नहीं मालूम।
97
69
69
909
909
787।
787। योर फुल नेम?
K.V.J राव प्लीज।
ओके सर, ओके, थैंक यू। मैं आपको उसमें बाद में कांटेक्ट करता हूँ।
गौरव सर, विल स्टार्ट नाउ। क्वार्टर सेंचुरी हो गया है प्लेयर्स का।
नीरज, are you there? He's there?
नीरज,
अच्छा, okay, नहीं, Neeraj is not there. चलो, never mind. He was messaging, so I thought maybe he's joined back.
no,
Okay.
maybe sir, we'll wait for 2 minutes otherwise, or maybe he can come on the mobile.
नहीं, मोबाइल पे भी वाईफाई लगेगा ना उसको? वाईफाई नहीं है ना, लाइट नहीं है, इसलिए वाईफाई नहीं है।
हाँ, ओके सर।
राजन किधर है? क्या दूध है? दूध बजा दूध।
Everyone mute yourself, please. We don't want the background sound over here. Mr. Rao, can we start?
Yes, sir. I'm waiting for your okay.
Right. No. I thought maybe, you said to wait for some time, so I was
Yeah,
waiting.
Neeraj.
Okay. Neeraj, I think it will be difficult because at Kalyan, the light goes off for quite some time, not
Okay, sir.
small gaps, it will be half an hour, 1 hour, something like that. So I've told him to
Yeah.
join in immediately once we get the light. Okay,
Yeah.
that's the
Okay.
electricity. Okay, so welcome everyone. सभी का स्वागत है एक और हमारे वेबिनार पे, पेटिशन ग्रुप के वेबिनार पे। हम ये रेगुलरली वेबिनार और एम्पावरमेंट एक्टिविटीज करते रहते हैं, जहाँ पे लॉ के बारे में, गवर्नेंस के बारे में सभी को ज्ञान देते हैं, गाइड करते हैं, और एक्सपर्ट्स हमारे वेब पे भी, वेबिनार पे भी आते हैं, या हम कहीं सेमिनार करें तो वहां पे भी हम इनवाइट करके उनसे हम गाइडेंस लेते हैं, एक्सपर्ट्स की, लॉयर्स की, ये लॉ के बारे में, गवर्नेंस के बारे में। तो एक सभी का स्वागत है। और हमारे साथ मैंने अभी नोटिस किया एडवोकेट तनवीर जी भी है। तनवीर जी जरा आप अनम्यूट करेंगे आपसे। एडवोकेट तनवीर जी।
Good morning, everybody.
Good morning, sir.
Good morning, Tanvir ji. So nice to see you along with us today.
Wonderful, wonderful. I look forward to this session, and I understand there
It's
is
a
loads
pleasure
of.
to have you with us.
Thank you, sir. Thank you, sir.
Yes, thank you so much.
Tanvir sir,
सबको
we
कहते
are
कि
subject to correction also, okay? Under your guidance.
Yes, absolutely, absolutely.
I'm here to learn, sir. Thank you, sir.
Yes.
We all are learning in the learning curve, sir.
Yes. एडवोकेट तनवीर जी को सबको समझा दे। एडवोकेट तनवीर जी एक एमिनेंट क्रिमिनल लॉयर है। हमारे कई साथी को भी उन्होंने केस लड़े हैं और जिताया है केस उन्होंने, तो हम उनके खूब आभारी है तनवीर जी। और हम चाहते हैं कि फ्यूचर में भी हमारे साथ रहो, हमारे ग्रुप में आओ, और हमें रेगुलर आपका गाइडेंस मिलता रहे, ऐसे हमारी प्रार्थना है आपसे। तो शुरू करते हैं तनवीर जी और सभी लोग कि आज का जो टॉपिक है ये सजेस्ट किया गया था हमारे वन ऑफ द एक्टिव मेंबर जोसेफ मैथ्यू जी ने, जो हमारे साथ है आज वेबिनार पे। उनका जो बिल्डिंग के जो प्रॉब्लम में लॉ का मिस इंटरप्रिटेशन और गैर कानूनी ये हो रहा, कानून का उल्लंघन हो रहा था हमारा एक्ट सेक्शन 95A का। तो उन्होंने अपने हिसाब से सभी को साथ लेकर लड़ा है। हमारे ये जो एक हमारे आज के स्पीकर है श्री K.V.J राव, उनसे भी ये गाइडेंस लेकर उनकी लड़ाई चालू है जोर शोर में। और ये आपको सेक्शन 95A का थोड़ा मैं बैकग्राउंड दे दूं। ये कानून इविक्शन के लिए होता है टेनेंट्स का, जब रीडेवलपमेंट करते हैं तभी। और तभी ये
कितना भैया और ट्रैवल टाइम कितना है? हाँ अभी
रेमेडी और these people I don't know. Okay, तो सेक्शन 95A का जो ये इविक्शन के बारे में सेक्शन है MHADA एक्ट में, ये इसमें फ्रीक्वेंटली मिस इंटरप्रेट होता है और बिल्डर के फेवर में करवाया जाता है, ये तीनों की मिली भगत से, बिल्डर्स की, MHADA ऑफिशियल्स की और लॉयर्स की। तो ये हमें जानना है हमारे एक्सपर्ट से आज, और जो भी लॉयर्स हैं हमारे साथ में, तनवीर जी और भी कई, हमें जरूर गाइड करें इस बारे में कि सेक्शन 95A किस सही रीत से इंटरप्रेट किया जाना चाहिए, और अगर ये गैर कानूनी करे ये ऑफिसर्स या लॉयर्स या बिल्डर, तो हमें कैसे उनको ये ठीक करना है, कैसे हमें लाइन पे लाना है। तो अभी ज्यादा समय न ये करते हुए मैं हमारे एमिनेंट स्पीकर जो आज के हैं श्री K.V.J राव और श्री अमित इसरानी जी, उनसे मैं रिक्वेस्ट करता हूँ कि शुरू करें। शायद अमित जी ऑनलाइन आए नहीं है अब तक, शायद बिजी होंगे, तो मैं रिक्वेस्ट करता हूँ श्री राव को कि आप शुरुआत करें इसके बारे में बोलने का।
Thank you, sir. Good morning, everybody. I'd like to thank this Petition Group Foundation and Joseph sir. More so Joseph sir, because he has got me involved into this MHADA Act. I was not dealing with this MHADA Act before, and He's got me involved, and that has given me a certain insight into how we can fight our battles with unscrupulous committee members, unscrupulous builders, and unscrupulous MHADA officers. Today, the subject that I'm speaking on is Section 95A of the MHADA Act. Before I go to that subject, let us read what the preamble of the MHADA Act is. Because we have to understand one thing, every act is created for the benefit of the citizens. No act is created only for a certain officer or certain. The act has to help the society, develop the society. So we have to look at what is the preamble of the MHADA Act. And if I may be permitted, I'll read so. The MHADA Act of 1976 is an act to unify, consolidate, and amend the laws relating to housing, repairing, reconstructing dangerous buildings, and carrying out improvement in slum areas. Now, Section 1A of MHADA Act of 97 declares as under. It is hereby declared that this act is for giving effect to the policy of the state towards securing the principle specified in Clause B of 39 of the Constitution of India and the execution of proposals, plans, or projects thereof, and the acquisition thereof, the lands and buildings, and transferring the lands, building, or tenements therein to the needy persons and the cooperative society of occupiers of such land or building. Now, let us read what 39B of the Constitution says. 39B in the Constitution of India reads as under, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. Therefore, in law, this is what my interpretation of the law is now. Therefore, in law, the officers of MHADA are the trustees of the property or tenement of the residence which is going in for redevelopment. And there is a now this is my lecture starts from here on. Now, MHADA is a mediatory government body between the society, that is the members or citizens of India who own properties or who are tenants in properties, and a builder who would like to take that building for redevelopment and build on it by undertaking a few things to the earlier residents so that they are not dispossessed of their property and they get better benefits also. Understand one thing, the act has been created in very good faith. It is the implementation of the act that has let us down very, very badly, and for obvious reasons. The obvious reasons are, once the power or an absolute power goes to a public servant, he thinks he owns everything, he can overwrite anything, he can do whatever it pleases him, and that is where the problem lies. Now let us read what is the statutory procedure for eviction under Section 95A of the MHADA Act 1976. It says, where the owner of the building or the members of the proposed cooperative housing society of the occupiers of the said building submits a proposal to the board for reconstruction of the building after obtaining the written consent of not less than 70% of the total occupiers of that building. Subsection 1 reads, and a no objection certificate for such reconstruction of the building is issued by the board to the owners or to the proposed cooperative housing society of the occupiers, as the case may be, then it shall be binding on all occupiers to vacate the premises. Now, every public officer or builder only reads Section 1. Subsection 1 he reads that, no, you have to vacate the premises. But to evict somebody from their premises, if that person is not vacating the premises within the framework of the law, nobody can force him. So what they miss is subsection 2, and that is the most important part. provided that it shall be incumbent upon the holder of such no objection certificate to make available to all the occupants of such buildings alternate temporary accommodation. Now, this is where the problem is. The problem lies that the builder, see, first of all, let me start from how this process starts. The society members get together, they pass a resolution saying that they want to redevelop their building. They say, okay, we've got proposals from X, Y, Z. Those proposals need to be discussed threadbare with its members, the pros, the cons. In fact, the pros are always there, but it is the cons that are never discussed. And that is where we lose our control over our property. We lose control over a lot of things. The builder then becomes the owner. He thinks like he owns everything. And that is where I got involved just now, because I felt like there was certain things happening wrong. And again, I am grateful to Joseph Matthew sir for having contacted me in one of the seminars of the petition group itself. Initially, I was very hesitant to get involved with this, but he told me, sir, you have to take care of this. You have to have a look at this. You are fighting criminal cases. You are fighting the government servants. You are fighting a lot of people. So why don't you help these people? And that is how I got involved with the MHADA Act. Otherwise, this was not my cup of tea. And once again, I thank him because it has enhanced my knowledge. Because once I read the preamble, I read section 95A, I got an insight into a lot of things as to how the problems of people whose buildings are going in for redevelopment, have gone in for redevelopment, can redress their problems. See, the problem basically is, and this is with due apologies, this is not against anybody. This is I make this statement with a caveat. It is unfortunately our own brethren, our own friends, our own neighbors, our own relatives who live in a society with us, when it goes for development for a few square foot more, or maybe a few lakh of rupees more, will sell the rights and interests of the other members, which is very unfortunate. And I have, after getting involved with these and the way I have looked at things, I have found that to be the basic problem for most of the redevelopment projects. Because these committee members have, either they are legally empowered or not legally empowered, whatever it be, have entered into a one-sided, lopsided agreement with the builder. Because once you have taken some benefit from the builder, understand one thing, he is going to extract that from the rest of the members. Builder has never come to you for charity. The builder is in the business of making money. He is not in the business of taking care of your interests. And if your interest is going to get harmed, it is for you to start fighting. Like, it is rather unfortunate that I'm looking at two cases which are right in front of me, where a winning proposition was given away on a platter to a builder by some lawyers who did not apply the law as it needed to be applied. I came into the picture when two residents were of Pantnagar were going to be thrown out of their houses by Dadagiri, basically, where we had MHADA officers saying, "Arey, tum jao kidhar bhi jao, mere ko iska lena dena." Imagine when the tenant went to the MHADA officer, and I'll name the officer because I've named him in the criminal petition, one Mr. Vatkar. He says, "Mala rent agreement se maza kai ghena dena nahi." How can an officer make a statement like that when the Act itself says that a rent agreement has to be in place before you evict somebody? And I'm making this statement with full responsibility. Mr. Vatkar must be making money from the builders. since I have studied the case, I have read the case, and he served them an eviction notice that in 48 hours they are going to be evicted. I have a good few lawyers who I sent them to, they said, no, we'll work on this. They worked on it. Imagine when we filed the petition and the petition came up for hearing, the builder meekly came to court and said, sir, I will sign the agreement. And that is an undertaking given by the builder to the court. So you imagine how the MHADA officers have been looting or depriving honest tenants of their tenements with no rent in place. Once you vacate the premises, you think the builder is going to listen to you? He's not going to listen to you. And I'll name this builder also. It is Siddhivinayak Builders of Pantnagar. They have damaged the property so that these people can't even live in that property. And the Pantnagar police are playing hand in glove with them. I mean, everything that says, ye mera kaam nahi hai. Agar police ka kaam nahi hai, if something illegal is taking place, imagine the other day the builder has given a letter to Adani Electricity saying remove all the electric meters. Who's the builder? Has the builder given any document from MHADA? What was MHADA doing? How did MHADA grant permission in the first place? And can a building be demolished without an IOD? Doesn't the MHADA officer know that unless an IOD is given, a building can't be demolished? And here you have builders who are demolishing buildings outright, without an IOD, without any clearance of their building plan. You see, 95A protects every. See, the builder says, "No, हमने society के साथ agreement किया." Tenement agreement, how can there be a tenement agreement between society and builder? Who's the tenant? The tenant is the person who has handed over his property, not the society. The flat is not the society's property. The society committee members are trustees of the property. The Maharashtra Cooperative Act is very clear that they will run the day-to-day affairs. So when they run the day-to-day affairs, they are trustees. MHADA officers are also trustees of your property. They have to see that all legal requirements are obtained, undergone, and executed before they give any permission to a developer or a builder. But does that happen? You go to MHADA office, more than the tenant, there are builders sitting there with the MHADA officers. Whether it is a registrar of societies, you name it, everybody has builders sitting in their office. Their office is run by the builder, for the builder, and of the builder. And because these tenements, I mean, I don't mean to demean anybody, are coming from the low income group or the middle income group, and they know that, they cannot fight a legal battle. They are taken advantage of by these people. And the officer who's supposed to protect you is the one who sells you. And the temerity of these officers are that, हाँ जाओ, जिसको बोलने क्या है बोलो. Imagine a builder saying, अरे मैं डरता है क्या कोर्ट से, मैं तोड़ देगा, क्या करेगा कोर्ट में देखेगा. Why has this stage come to? This stage has come because every public authority has been taken over either by money power or by political power. The builders find it very easy to pay money to these people than to give the legal dues of the tenants. Have you not seen how redevelopment buildings have not been redeveloped for 10 years, 20 years, and nobody's talking about it? You think, come election, all your politicians say, but for that very election, the money comes from the builder and the developer. So you think that politician is going to take care of you? He's not going to take care of you. And unfortunately for us, we have neighbors, we have friends who say, "अरे क्या लफड़े में पड़ता है यार, छोड़ो ना, जो दे रहा है ले लो." जैसे कि बिल्डर सबको भीख दे रहा है, या माड़ा ऑफिसर किसी को भीख दे रहा है, या पुलिस इंस्पेक्टर किसी का मेहरबानी कर रहा है कंप्लेंट लेके. It is your friends who don't stand by you. It is your relatives who don't stand by you. And unfortunately, I beg, with due apologies to some of the lawyers on this forum, I have seen many a lawyer let down their clients. And for reasons best known to them, I would not like to make a comment on an open forum on that. Not that I'm scared of defamation, I can prove it.
Sir,
And-
many lawyers are also corrupt, sir. Therefore, they're doing this.
No, I am not getting into that. I am not getting into that, sir. Please forgive me. I am only going by what has been my observation, at least in one matter in the Pantnagar case, where the judges were in favor of the tenants and the lawyers did not bring it to the notice of the next bench. Imagine where a judge in the open court told the developer, "तुम कैसा इन लोगों को vacate करते हैं हम देखेगा, जब तक तुम 8 लाख रुपया और 2 फ्लैट separate bank guarantee 8 करोड़ और 2 फ्लैट separate रखोगे, which you cannot sell till the whole building is redeveloped." The next day, that the builder comes and says, "मैं 2 करोड़ दे सकता हूँ," and it is agreed by the next bench because the next bench was not told that the earlier bench had said this. It is unfortunate. If I were their lawyer, I would immediately go back to the earlier bench and ask for a speaking to the minutes, an order for speaking to the minutes. And lawyers, kindly correct me if I'm wrong. If the judge, honorable judge, has made a statement in open court, I don't think he will backtrack from that statement. So if you have a problem today, it is only because of some unscrupulous element somewhere in the society who wants to take advantage of you to fill their stomach. That is why I started with the preamble, is to say that the MHADA Act, MHADA is the trustee of my property. So the moment a 95A notice is given to any tenement without the board of directors resolution of MHADA, or a rent and not or, it is and two clauses of the act, the MHADA or any public servant cannot evict you from your premises. But you have MHADA officers who have broken properties, who have demolished buildings with a 95. Imagine a 95A application is pending in court and the MHADA officer says, "Oh, court mein hai na? Order aaya kya?" There is a judgment of the Bombay High Court by Justice Gawai who has said that once the High Court is seized of a matter, till it is heard, no coercive action should be taken. Heavens are not going to fall down if in a month or two the matter is to be heard and the process is delayed. The builders basically are interested in demolishing the building so that the tenants don't come back there. And they don't have to deal with them on a daily basis. Can you imagine your own colleagues, society members write a letter to MHADA to issue a 91A notice, and the MHADA issues that notice also? Who are the society members? What authority they have under 91A and 95A to issue a letter to MHADA? Under which rule? Under which rule, act? Tell me, or law, tell me which society committee members or managing committee members have the right or even an individual member has a right to go right to MHADA saying evict this tenant illegally. Therefore, like I said in the beginning, it is your own friends who lived with you for 30 years, 40 years, 50 years for 4 rupees and 4 square foot will sell you off. And I make this statement with full conviction and with full responsibility. And you will find these type in every society, wanting to milk the society for their personal benefits. So, when we got this order from the Honorable High Court of Bombay saying that unless the agreement is signed, you cannot evict the tenant. Imagine the MHADA officer now writes a letter to the builder saying enter into an agreement. What was he doing for all these years? Is it that letter of the MHADA officer reflects his culpability and reflects his conspiracy with the builder of having issued the notice without authority in the first place? Does he have the right to violate a statutory provision? If the statute says 2 issues, Board of Directors resolution and a rent agreement with the builder, mind you, not with the society. Because if there's an agreement between a society and the builder and the landlord, the tenant is left hanging. Tomorrow the landlord will throw him out, say, "Tum kaun hai? Mera agreement thodi hai aapke saath." So individual agreement with every tenant is a mandatory requirement before eviction. Like I said, if I get into a matter, I get right into the crux of the issue. And many lawyers have forgotten or have not even read this section. Or if they have read it, and if the tenants have suffered, then I'm proved right in my statement. I mean, we all make a living out of our profession. I'm not saying no, but do you overnight you want to fleece somebody? I mean, these people that I met, they paid their lawyers up to 8 lakh rupees. They have sold their jewelry to pay the lawyer. After which, despite the judge making a statement in open court, that statement was diluted by the lawyers itself, not even challenged. It is another matter that one of the judges sitting on the earlier bench was sitting on this bench, but he will say, I didn't know this was the same case. This, despite the Honorable Supreme Court in numerous judgments has said that it is for the judge to apply the law even before the parties ask him to apply the law. The judgment is authorized officers of State Bank of Travancore versus MC Matthew. Paragraph 16. But does it happen in court? The court says, you bring it to my notice, I will address it. Like I said, I never got into these MHADA acts, but I've been exposing corruption for a long time. I've been a victim of high-handedness. I was sent to a lockup for 11 days for exposing an 80,000 crore corruption. If today most of you all are breathing free for talking either on the Facebook or WhatsApp or anything, it is thanks to me. Section 96A was taken off the act because of 10 important cases, and I and my colleagues was one of them, of the misuse of that law. Therefore, now when I look at a matter, I look whether this can be converted to a criminal issue. And 95A, if the MHADA officer has issued a notice without the Board of Directors resolution and the rent agreement, he is criminally liable for not following the directions of the law, section 166A, section 409, because understand one thing, you have now entrusted your property to him. So there is entrustment. And 409 comes directly into play. 120B, criminal conspiracy. There is a latest judgment of the Honorable Supreme Court on 22nd June, which clearly says that statutory provisions, no person, including the court, has powers to amend it. In fact, if I'm talking of judgments, way back in 1977, the Constitution Bench of the Honorable Supreme Court held in the Supreme Court Bar Association versus Union of India that even under Article 142 of the Constitution, which is the plenary powers of the Supreme Court to do justice over and above what is required, the courts cannot violate the statutory provisions. And here you have a lowly MHADA officer violating the statute left, right, and center. We all, the moment you go to a police station to file a case against a MHADA officer for not following the statute, they say, "Sahib, to public servant hai, sanction aanar tumi." All of us forget that the Constitution Bench of the Honorable Supreme Court has held that at the time of filing the FIR, no sanction is required. Only if that public servant has been caught under Prevention of Corruption Act, prior sanction is required. There is an amendment to that act. There is no amendment in the MHADA Act that anything protects that officer. And let me tell you, even if there is an act that protects an officer, it is only for acts done in good faith. It is not a blanket ban. Like I was before a bench that said, Mr. Rao, there is a notification issued by the government of Maharashtra on 30th August 2016 that a magistrate cannot direct the filing of an FIR under 156(3). So I said, "Sir, I'm not aware. Can you show me that circular?" So he said, "How are you saying that?" I said, "Sir, I'm asking you to show the circular because you made a statement. Can I have a look at the circular at least? We can adjourn. You want to adjourn for a week, 10 days, 1 month, I don't mind, but I need to read that circular. Or you give me time to get the circular, I'll read it and I'll say whether it applies in the present situation or no." And then when I read, it's simply the notification issued by the government of Maharashtra simply says that an order against a public servant cannot be passed if the action is in line of duty. That's exactly what the IPC also says, or the CRPC also says. So there is no blanket ban. Yes, the magistrate now has to look into whether the act of the public servant was in line of his duty. So if there is criminal breach of trust, if there is a public servant not following the directions of the law and the statute, how is he going to get protection? Who is giving him protection? The only people who give protection to the MHADA officers are their political masters. And there was a challenge put to one of the persons that I am representing today, ki tu kasa kai ghar khali karat nai bagto. He told the MHADA officer, "Yala haklun dia je hoil te hoil mi bagto." Imagine a housing minister coming and making such a statement in an open forum. And today that man is protected by an order of the Honorable High Court. So you see the amount of respect that the politician and the officer has for the law. And these are our lawmakers.
So could you repeat that in Hindi, what he said?
Sorry?
Could you repeat that in Hindi? Because most of the people over here, they are not aware of Marathi. So,
एक ओपन फोरम में मंत्री जी आके माड़ा ऑफिसर को बोलता है कि ये आदमी बहुत नाटक कर रहा है ना, इसको हकल दो घर से, मैं देखता हूं क्या होता है, कौन आता है इसको बचाने के लिए, मैं देखता हूं। और जब हम कोर्ट के दरवाजा खटखटाए तो कोर्ट ने हमको प्रोटेक्शन दिया। अब किधर है वो पॉलिटिशियन? अब वही माड़ा ऑफिसर ने तो लेटर दिया कि एग्रीमेंट, रेंट एग्रीमेंट बनाओ आप बिल्डर को। तो ये माड़ा ऑफिसर को पहले नहीं था कि कानून क्या है? हम ये भूल जाते हैं दैट इवन अ रीडेवलपमेंट एग्रीमेंट, there have to be protection clauses protecting the tenants. The unfortunate problem is, like I said, it's our own people, our own friends, our own relatives, our own, as they say in Hindi, घर का बेदी लंका डाता है। अपने को बाहर वाले की कोई जरूरत नहीं है। Today that one of the builders is telling the rest of the residents, जब तक आप ये आदमी को घर खाली नहीं करवाते हो ना, मैं आपका रेंट भी नहीं दूंगा, because they don't have a rent agreement. And we had a discussion with the builder and I said, sir, आप क्या कर सकते हो वो बताओ, क्या नहीं कर सकते वो भी बताओ, क्योंकि आप जो नहीं कर सकते उसका हल कैसे निकालेंगे हम बताएंगे ना आपको। Because I don't think any resident of any society would not want to live in a better premises, would not want to live in a better surroundings. Greed has no place in this. Understand, if you're greedy, you will lose. It will be like the dog and the bone. Or as they say, bird in hand is worth two in a bush. Yes, in certain circumstances, yes, but not always. And इसीलिए now हम लोग ने क्रिमिनल केस फाइल किए हैं अगेंस्ट द माड़ा ऑफिसर्स, और हम देखना चाहते हैं कि कोर्ट कब तक उनको प्रोटेक्ट करेगी, किस हद तक जाएगी कोर्ट उनको प्रोटेक्ट करने के लिए। काफी कोर्टों में मेरे को मना किया गया है टू आर्ग्यू, एंड आई सेड सर, सुप्रीम कोर्ट की जजमेंट है, आप पढ़िए। मैजिस्ट्रेट कोर्ट में मैं आर्ग्यू कर सकता हूं दूसरों के लिए, अपने लिए तो मैं राइट अप टू सुप्रीम कोर्ट में आर्ग्यू कर सकता हूं अपने लिए, और मैं करता भी हूं। आई हैव परमिशन फ्रॉम द ऑनरेबल बॉम्बे हाई कोर्ट टू अपीयर इन देयर मैटर्स and in my matters. There are laws in place. Yes, it takes time. It takes time, but you have to bear the brunt of certain things where you can get it back afterwards. Today, this builder in Pantnagar is all he's doing is getting things robbed from somebody's house or damaging their property. Imagine the municipality is sleeping that a pipeline above this tenant's house is flowing with water. बॉम्बे में पानी की किल्लत है, लेकिन पंतनगर में ये बिल्डिंग में कोई नहीं रह रहा है, बिल्डर ने पाइप तोड़ दिया है, पानी बहते जा रहा है, पानी बहते जा रहा है। ना पुलिस को पड़ी है ना म्युनिसिपैलिटी को पड़ी है। क्यों? अकाउंटेबिलिटी नहीं होता इनके पास। और जब तक आप इनको अकाउंटेबल नहीं करोगे, कोशिश तो वो करेंगे, 1000 कोशिश करेंगे आपको तकलीफ देने की, लेकिन ये दो फैमिली जिनको मैं मिला हूं ना, मैं हाथ जोड़ के नमन करता हूं उनको कि एटलीस्ट मेरे थोड़े बोलने से, दूसरे के बोलने से उन्होंने स्टैंड भी लिया। ऑफ कोर्स वो डर गए थे, फिर मैंने बोला कि सर ये तो होगा, लेकिन हम बैठ के देखते हैं क्या करना है इसके बारे में। तो हमको हमारा सुरक्षा ही करना पड़ रहा है आज। देयर इज नो स्टेट टू प्रोटेक्ट यू। स्टेट बोलते हैं हमने कानून बनाया, आप अभी कानून के दरवाजा खटखटाओ। It is fortunate that there are good people in every fraternity. It would be wrong on my part to paint everybody with the same brush. It would be very wrong. Like, आप सोचिए, आपने अंडरटेकिंग दिया है कोर्ट में कि मैं 2 दिन में करार करता हूं। आज 3 महीने हो गए सर, वो करार के लिए नहीं आया, लेकिन रोज आके धमकी देके जाता है। रोज ऐसा एक दिन नहीं है जहां वो आके धमकी नहीं देता उनको। मुश्किल से उसी पंतनगर पुलिस स्टेशन में हम लोग ने 14 एफआईआर भी करवाए अगेंस्ट द बिल्डर फॉर नॉट पेइंग द रेंट। बिल्डर ने एंटिसिपेटरी बेल के लिए अप्लाई किया, जज साहब ने उस पर लिख दिया कि दिस इज अ सिविल मैटर। नाउ जज वही लिखेगा जो या तो पीपी बोलेगा या सामने वाले का वकील बोलेगा। पीपी तो कभी बोलेगी नहीं। कि बॉम्बे हाई कोर्ट के जस्टिस काटावाला ने लिबर्टी गार्डन्स के जजमेंट में क्लियरली लिखा है, any cheating to the society or to the members of the society is not a civil offense, it's a criminal offense. और मलाड पुलिस स्टेशन के सीनियर इंस्पेक्टर को कटघरे के पे खड़ा किया था। उसने माफी मांगी तो ये छोड़ दिया और बोला कि आप आके इधर माफी मांगते हो, लेकिन वापस जाके आप यही करोगे दूसरे मैटर में। And that is why you find most of these people saying, जा ना कोर्टात जा। अगर हर चीज हमको कोर्ट से ही लाना है तो पुलिस की क्या जरूरत है? बाकी पब्लिक सर्वेंट की कोई जरूरत ही नहीं है ना। लाइक कोई मेरे को आके पूछा, सर वो पंतनगर में आपका क्या लेना देना उससे? अरे भाई, जब मैं इसलिए रुकूं कि मेरे घर तक आ जाएगा आग और तब मैं भागूं? और यही एक कारण है कि तुम लोग को डोमिनेट कर सकते हैं। अरे मेरा प्रॉब्लम नहीं है ना, लेकिन जिस दिन तुम्हारे घर में प्रॉब्लम होगा, कौन खड़ा रहेगा आपके साथ? आप अगर लड़ नहीं सकते हो उसके साथ, एटलीस्ट उसको गाली तो मत दो। डोंट डिमोरलाइज अ पर्सन हु इज ट्राइंग टू फाइट फॉर हिज राइट। अच्छा नहीं कर सकते ना, ठीक है, तो चुपचाप बैठो, बुरा तो मत करो। Imagine the society members have gone to MHADA office and told the MHADA officer, इन दोनों को कैसा भी करके निकाल दो आप घर से बाहर। क्या हक है उनको? क्या हक है उनको?
सर जैसे आपने बोला कि अभी पुलिस एफआईआर नहीं करती है, बाकी के जो अथॉरिटीज है वो भी करप्ट है, कोर्ट भी इसके ऊपर कोई एक्शन नहीं लेती है, फिर ये जो विक्टिम्स है उनके पास क्या ऑप्शन है? मतलब इसका सोल्यूशन क्या है?
कोर्ट भी कोई एक्शन नहीं लेती है, इसलिए है कि कोर्ट में समटाइम्स द केसेस आर नॉट प्रेजेंटेड प्रॉपर्ली, they are not represented properly, and yes, the courts also take everything very leniently. मेरा इसी विक्रोली कोर्ट में हुआ है, where a magistrate behind my back says there is an order issued by, there's a judgment issued by the Nagpur bench. So I'm rejecting his application. But when I was arguing the matter, he didn't produce that judgment before me. Because that judgment was totally wrong. Totally wrong.
मैजिस्ट्रेट भी बोलते कुछ और है, करते कुछ और है ऐसा.
Yes, sir. But the thing is, आप देखो सर, इसीलिए उस मैजिस्ट्रेट को मैंने सेशंस कोर्ट में अक्यूज बनाया. सेशंस कोर्ट जज भड़क गए, बोला अगर मैं गलत ऑर्डर पास करूं तो मेरे को भी अक्यूज बनाओगे. सर क्यों नहीं सर, आपका सुप्रीम कोर्ट ने ही बोला है, R.R. Parekh versus State of Gujarat, that an order passed by a judicial officer is proof of his corruption if he has not followed the statutory requirements of law.
और सर बहुत सारे लोगों के साथ में जैसा आपने बताया अन्याय होता है, तो उनको कंप्लेंट करना चाहिए. मतलब कोई भी अथॉरिटी रहने दो, चाहे वो माड़ा हो, पुलिस हो, चाहे वो जज हो, मजिस्ट्रेट हो. बहुत सारे लोग डरते हैं कंप्लेंट करने से, तो उसके बारे में आप क्या बोलोगे?
सर गब्बर सिंह ने वही बोला ना, जो डर गया वो मर गया.
So
अगर डर के ही जीना है तो फिर सर जो वो दे रहा है वो ले लो ना, फिर आवाज ही मत उठाओ ना. आवाज उठाओ, या तो मारो या तो मरो. ये बहुत रेवोल्यूशनरी हो गया मेरा ये स्टेटमेंट. बट द एंड इज दैट यू हैव टू फाइट टिल द एंड. दिस इज अ वन वे स्ट्रीट नीरज. या तो इसमें आप चलो, ये रास्ता कोई आसान नहीं है. ये मैं आपको पहले भी बोल चुका हूं, अभी भी मैं बोल रहा हूं, ये कोई आसान रास्ता नहीं है. बट आप 2 जन को हिला और देखो बाकी लोग कैसे हिलते हैं. अभी जी जोड़ के मेहनत चल रहा है कि कैसे भी करके विक्रोली कोर्ट से वो केसेस हटाया जाए, जी जोड़. बट आई एम स्टिल गिविंग द बेनिफिट ऑफ द डाउट टू द जुडिशरी दैट आई विल गेट जस्टिस.
और सर मोस्ट ऑफ द केसेस में
परसों भी मैंने आर्ग्यू किया. वही मैजिस्ट्रेट जिसने मेरे पीछे ऑर्डर दिया ना, उसी के सामने दूसरा मैटर में, और मैं ये बोला उसको, the problem is most advocates will agree with me. हम प्रेयर क्या करते हैं कि हमको 1 2 3 4 चाहिए, और 4th में बोलते हैं any other order in the interest of justice. और यही एक प्रेयर लेके मैजिस्ट्रेट बोलते हैं in the interest of justice. I think this case doesn't merit any case. And this has happened to me, where a 156(3) application was converted to 200. I said, sir, how can you do that? I didn't make a prayer. तो कहते हैं read your clause, any other order in the interest of justice. उस दिन के बाद आज तक नीरज मैंने कभी वो ऑर्डर नहीं डाला, मैं कभी वो प्रेयर किया ही नहीं उसके बाद. इनफैक्ट एक विक्रोली मैजिस्ट्रेट के कारनामे की वजह से मैंने अभी एक और प्रेयर इंक्लूड किया है कि before passing the order, if the magistrate would like to rely on any other judgment that is not brought before me, or seeks clarification on the citations, the judgments, or the averments made by me, I am willing to submit myself before this court, and then only an order be passed. Drastic diseases need drastic medicine. मैं ये भी बोला सर, this is the last, उसी को बोला, this is the last bastion that the citizens come to when the executive and the legislative legislators fail them. And he smiled. He smiled. वो क्या ऑर्डर पास करेगा 15 तारीख को मेरे को नहीं मालूम, बट अब की बार मैं 482 में जाऊंगा फॉर एक्शन अगेंस्ट हिम, बिकॉज उसने जो जजमेंट यूज किया वो जजमेंट का कुछ भी लेना देना नहीं था इस केस से. इनफैक्ट उनका जजमेंट went in favor of me. Had he allowed me to argue, मैं argue भी कर सकता था, and I will discuss that judgment also if you want. एक बिल्डिंग में विदाउट ओसी किसी को जबरन घर दे रहे थे, मैं बोला आप मत ले, तो बिल्डर बोला नहीं लेगा तो मैं ये करेगा वो करेगा. We went to court saying, sir, without OC asking me to enter into a building, it is I don't know whether it is a dangerous building, I don't want to put my life at risk, so it is endangering my life. So taking that plea of mine, he produced this judgment and it's a very famous judgment. Let me tell you. It's a very famous judgment in the sense when the IPL was being held in Nagpur, they had built a stadium only for the IPL. The holding capacity of that stadium was some 65,000 people. Later on, somebody came to know that 72,000 tickets were given out, complimentary as well as saleable. So he filed an FIR. The FIR was filed in Nagpur against the officers who gave sanction for that stadium. When the FIR was filed, immediately everybody got into action and they rectified the structure in such a manner to hold 72,000 people. So the Honorable Justice who passed that order should have realized that because they rectified their mistake, an OC was granted. So that means otherwise it is endangering life, right? It's a clear-cut case of endangerment where job building or the structure is not willing to take a particular load. You put more load on that, it's endangering life. Same thing in a building. If the builder has not got the OC, that means there is some problem in the building, no? Which now, if you read last week, the Honorable Bombay High Court passed an order and asked municipality that how did you give an OC to him if the water line is not there? Water is a fundamental right of every citizen. So if you don't give water to me, good water to me, you're not endangering my life. I'm drinking polluted. He said the judge has observed in his judgment that they are drinking polluted water. And the builder is not doing mehrbani by giving 20 liters of Bisleri bottles.
Sir, and earlier you had said that, the public prosecutors in the court, basically they don't say anything because they are managed by the builders and the accused. Okay, yes. So in that cases, because the state, it's the state which argues and the public prosecutor is the one. So in that cases, what can be done?
The thing is, unfortunately for me, when this happened in our matter, I was not in the court. It was only after the order was passed that on the day the order was being passed, and the PP looked at me and said, bad luck. I said, Madam, bad luck noti. Arguments zalele naute. Okay. There was a remedy where I could go to the High Court to appeal against that, Neeraj. But the fact remains is even the High Court will say, what is the harm in granting him bail? Because the Supreme Court has held that sending somebody to jail is not the panacea to all evils. He says, why do they send somebody to jail? So that his presence for investigation is required. If the judge has put that clause that yes, he will attend the police station for investigation whenever he is caught, I will lose the case in the High Court. So we'll be wasting good money after bad. I mean, the Supreme Court has held that the victim cannot be kept out of the system in innumerable judgments. But the fact remains is that very court also says that you cannot argue. You can only assess the PP in the Sessions Court. In the Magistrates Court, you can argue. But Sessions Court and above, the party, you can engage a counsel, but your counsel will only guide the PP. But if the PP doesn't do his job, or is not planning to do his job, then what can the others do? Even if you take the best of lawyers, he's not going to be heard directly by the judge. So you've lost the case. So somebody needs to file a case saying that no, we have to be party in the case. That is why now, and I'm surprised. I am also surprised in this, that in the anticipatory bail, no notice was served to the complainant. At least the victim can go to court to brief, no?
Sir, is there any
The-
mandatory clause in which, through any judgment or through any guidelines or circular, which says that, when the accused is applying for an anticipatory bail, then the complainant has to be informed of the same?
Neeraj, you have to understand one thing, Neeraj, no judgment will be written in the words that I and you want. But when the Supreme Court holds that the victim cannot be kept out of the system, it means the victim needs to be informed, no? You have to read into a judgment, Neeraj, which I have learnt over the years. If the victim cannot be kept out of the system, then it means that the victim has to be intimated. There should be intimation to the victim, no?
Sir, but you and me, we all know how the court twists the
Sir,
judgment as per
Neeraj,
their
when that
convenience.
happens, see, that is no. So those people who also were very upset. They told me. I said I will address this when it comes, because now what has happened is now the police are not even calling that person for investigation. Okay, and we are moving. It is unfortunate that there are 13 or 14 people getting those 14 together to come and do something. It is taking me some time, but we'll do it. Just because the Sessions Court judge has made some statement, it doesn't mean it doesn't mean that it is the gospel truth. In law, the advocates can correct me. This order is nothing but a per incurrum judgment. That is, it is a judgment made without referring to case laws, or the proper case laws were not presented to that judge. And unfortunately, the case laws have to be presented by the PP. Because I am not allowed to argue, the victim is not allowed to argue. No.
Sir, can we start taking question and answers now?
Neeraj, you already started it, so we can go further.
Okay, sir. Manisha.
So nowadays I have seen that apart from 95A, can you hear?
Yes, sir.
Apart from 95A, the builder are managing the MHADA person. They come and they file a report that the building is structurally unfit.
Yes.
And then even the tenants run to the structural report. And these reports are presented before the TAC committee. And even the TAC committee has been in collusion with the builder, declared the building unfit, and they go in for a demolition. So what happens? The building gets demolition, the plot is open, and tenants are left with on the road. So in a recent matter against Rabatwala Reality, we have filed a writ petition in the Honorable High Court, wherein High Court did dismiss the writ petition only with an observation. Not passing any order, not passing any protection. The building is in an habitat condition. There are two reports, one from the MHADA and one from our side. Structural. One is telling that the building can be repaired and can be stand.
It can be inhabited.
We are going on the other side. Now this is a very crucial stage where we are left with no option only. Even court is
then,
not,
sir, then did you
interfering
make a suggestion that a court appoint a structural engineer to conduct the audit?
No, sir.
Then, see, when you go to court, don't go with your problems, go with the solution. Say, Your Honor, this is our report, that is their report, and we both are fighting here. So why don't you appoint a structural engineer? We both will pay for it, and let him come to a conclusion.
So sorry to interrupt. Long back only they have opened one tech committee, that is technical something. The name is there. These both reports are presented before them for deciding.
Correct, sir. Now you're now again.
The committee form has been managed by in collusion with the
Manish sir, we have had this discussion n number of times.
Right.
I am telling you that they have managed the TAC committee. No, you are challenging the TAC committee report also, no?
Right, sir.
Before the Honorable High Court.
Both the report. Their structural engineer.
So that is what I'm saying. Na, Shah Sahab, you should have gone and said, sir, hamara report hai, unka report hai, but there is a problem. So why doesn't the court appoint?
The court is telling we have appointed a TAC committee for that.
No,
And that report is final
no, TAC committee is appointed by whom, sir?
by the court only.
Huh.
By an earlier order, they are only implemented them by direction that you open a tech committee where this problem can be resolved.
Correct,
And
sir. So if you have no faith in the TAC committee, you have to bring that to the notice of the court, no?
we brought it, no, sir, but the court instead of giving some direction, just dismiss the writ petition with an observation.
What is the observation?
Observation is tech committee report and all that. What are the procedures and all that? Yes, the court is enclosed as an annexure with the order.
But have all those procedures been followed?
Yeah, the only thing is the court has said that before demolishing the building, you should give the to all each and every tenant a certified area. Then how much they are certified with how much area they are in occupation and has to be certified. Now that the builder will do it because now the builder is what, so it's a non-sex property. He is not getting any benefit after redevelopment also. So what he is applying a pressure techniques, once the building gets demolition, tenants are out, then tenants will approach me, I will pay them amount and I will get the premises vacated and then I will construct the building. And it's a prime location like Tardev.
Sir, if you don't sign the agreement, what is he going to do? How is he going to?
Sir, they will demolish and I am on the road now, sir.
Sir,
my business is
sir.
effective.
Yeah, either you challenge this in the Supreme Court or you're, sir, sir, I totally sympathize with you. I agree. But if let us assume like tomorrow you're thrown off on the road, आप क्या करोगे? आप क्या करोगे? आप कहीं तो भी घर भाड़े पे लोगे ना सर?
सर ये तो बिजनेस मेरा है, मेरा बिजनेस उधर है तो सर मैं भी हेल्प ही कर रहा हूँ, मेरा कुछ लेना देना नहीं है इनसे.
हाँ जी.
आई एम ओनली गाइडिंग देम.
I understand, sir. I appreciate. मैं उसके बारे में नहीं बात कर रहा हूँ, सर. So we have to tell them कि हाँ भाड़े से रहेंगे. जिस दिन बिल्डर, देखो सर, बिल्डर भी, मैं आपको एक सिंपल सा बात बोलता हूँ, बिल्डर को अपने किसी से पैसा नहीं डालता, वो फाइनेंसर से लेता है.
बराबर है.
उसको भी इंटरेस्ट देना है. बराबर है. और आप जितना उसको डिले करोगे उसका ही नुकसान है.
और हम तो रिडेवलपमेंट के लिए ना ही नहीं बोलते बिकॉज़ इट
इज सर मेरा पहला स्टेटमेंट वही था कि कोई टेनेंट इन अ बैड बिल्डिंग इज नॉट गोइंग टू ऑब्स्ट्रक्ट अ रीडेवलपमेंट.
एग्जैक्टली.
यस, बिकॉज़ बट सर व्हेन यू हैव टू फाइट, सर फिर फाइट करना पड़ता है. तो आप कोई भी आप बिल्डर के साथ एग्रीमेंट ही साइन मत करो. बिल्डर क्या बिल्डिंग खड़ा ही नहीं कर सकता है, उसका पैसे लाखों का नुकसान हो रहा है उसका. सर पर
अभी तो उनको फाइनेंशियल, उनके पास तो सब है, मरते तो सब टेनेंट है ना सर.
सर मैं आपको वही बोल रहा हूँ ना सर. आप यही सोच के चल रहे हैं उनके पास सब है. सर जो आदमी प्रॉब्लम में है वो कोई आके बोलता है ना मेरे को प्रॉब्लम है. ओके, मैं अभी जो सर्टेन केसेस दैट आई एम हैंडलिंग, बिल्डर ही मेरे को बोल रहा है कि सर ये डिले होएगा ना तो मेरे को इंटरेस्ट भरना पड़ रहा है, मेरे किसी से जा रहा है. अच्छा सर, वो आपका प्रॉब्लम है ना, तो बैठ के बात करो ना. आप तो बैठ के बात नहीं कर सकते हो, आप आते हो, चिल्लाते हो, चले जाते हो. सो अल्टीमेटली यू हैव टू ब्रिंग द बिल्डर टू कम टू टॉक टू यू बाय ऑल दीज थिंग्स. पेशेंस तो होना चाहिए सर. ये कोई रातों रात जंग आप नहीं जीतोगे. ये एक बात आप पक्का जान लो. ओके, चलो नीरज, नेक्स्ट क्वेश्चन.
Zuzair Nagre, are you here? If you are here, then kindly please unmute yourself.
Yes, sir. Yes, sir. Thank you very
okay.
much. Thank you very much, sir. See, I have written my submission also. Maybe if the sir can able to read that. In a very
sir, he won't be able to read whatever is written on chat. You just explain it to him whatever your issue is within 2 minutes, and accordingly ask your question and be precise on that. Okay.
Small, yes, yes. Thank you very much, sir. There is a property in Mumbai South. Can you hear me, sir?
Yes, sir.
There is a property in the Mumbai South where lot of blunder is done by the builder, and 95A bogus notice also were issued And instead of taking NOC consent, and sorry, no, without taking the consent, they obtain the NOC and IOD. You know that how the builders they work. So 95A भी duplicate उन्होंने issue किया सिटी कोर्ट में कोर्ट रूम नंबर 9 में 2018 में मोरे साहब थे और fortunately the tenant were able to obtain the order against builder for the first time. They say that in the history it has happened. Not only that, in spite of getting an order second time वापस, after 1 year they went again to the court and they again tried to issue another notice to the tenant, and which was also a contempt. So the tenant obtained the second order also. Now the thing is, my current situation is such that we have been protected because of the court order. So there is nothing to fear about. But the only thing is that the building requires repair. And for that, we are approaching all the department, including MHADA HO. The current situation is that CEO, after a lot of efforts of 1.5 years, finally allowing us to proceed with the hearing, but the hearing is just for the namesake. They are saying only one thing, that Baba, the NOC once issued cannot be issued to another. भाई आपने बिल्डर को NOC रॉन्ग दिया है, टेनेंट को रिपेयर के लिए परमिशन चाहिए यूजिंग द MHADA फंड, why you are not allowing us? So they are not saying anything and they're just doing time pass by calling.
Nagarji, I'll ask you one simple question. Anything in writing on this?
What?
About can't give permission to somebody else once an NOC is given to somebody?
No, sir. They are just saying orally.
Exactly, na sir. एक legal notice भेजो, you are filing a criminal complaint against the MHADA officer. देखो वो कैसे भाग के आता है sir.
Sir, tomorrow we are having a final hearing date. I'm going with my lawyer, and then we will say that because they are saying the same thing.
Sir, forgive me for what I say right now, but मैं civil court जाना छोड़ ही दिया sir.
Okay, okay.
Criminal court में आप, if you have that civil court order which says that there are certain wrongs that have taken place, convert that into a criminal case, file a case. No magistrate will say no with a high court order.
Okay.
Or any other court order. See sir, अपना क्या है ना, we are barking up the wrong tree now. वो civility का stage चला गया sir.
Okay.
मेरे को आप पूछेंगे ना, I have won cases in the high court where the high court has recorded that yes, there are certain wrongs that have taken place. But मेरे को बोला गया है तुम करो, हम लोग करेंगे. आज मैं criminal case file किया हूँ, वो इतने झूठ बोल रहे हैं. They have engaged the topmost criminal lawyer in Bombay who has forged a document in the high court, and I have filed a 340 application against him.
Okay.
So ये अभी civilly बात करने का वो stage चला गया sir.
Absolutely sir.
जो भी करना है ना, criminal side पे करना है, you have a lawyer, you tell me, I will brief him how to get the thing done.
Okay.
And just go ahead. ये sir ये क्या होता है ना, ये shadow boxing होता है. Civil court, civil procedure जो है ना, is practically shadow boxing because you're boxing with a shadow. वो officer आपको document नहीं दे रहा है, कुछ writing में नहीं दे रहा है, लेकिन आप लड़े जा रहे हो.
जी sir, absolutely.
So you have to put a right thing on right. This मेरा एक अच्छा आदत बोलिए या गंदा आदत बोलिए. अगर मैं आज आपके साथ मीटिंग करता हूँ ना, सर मैं घर आके उसको एक ईमेल भेज देता हूँ
जी
कि सर आज ये मीटिंग हुआ था, ये डिस्कस हुए थे
जी
ऑन रिकॉर्ड. तो अगर वो एक साल के बाद आके बोलते ऐसा कुछ हुआ नहीं, बोला आपके पास मेल है रिबर्टिंग दिस. सो लर्न टू establish your right step by step, sir.
Absolutely, sir.
And I'm telling you, talking civilly to these people, that stage is over now, sir. And this is my suggestion to everybody. Okay, unless you are going to be evicted tomorrow night, go to the High Court to get an interim order. After that, move the criminal court. Because interim order also, understand, will be given based on certain logical reasons. So use that logic, whether you can use it on the criminal side. जैसे मैंने बोला, अभी जब मेरे को माड़ा का ऑफिसर राइटिंग में देता है कि सर बिल्डर हैज टू एंटर इनटू एन एग्रीमेंट, तो आपने 95A नोटिस कैसे निकाला? क्या हो गया ना सर, हर किसी को लगता है ना कि मैं माड़ा में बैठता हूं तो पूरा बॉम्बे का जो प्रॉपर्टी है ना वो मेरा पैटर्नल प्रॉपर्टी है। एंड दीज आर द वर्ड्स ऑफ द ऑनरेबल बॉम्बे हाई कोर्ट। जैसे हम जिसको हम हिंदी में बोलते हैं बाप का माल समझता है। The court has been very considerate to put it in parliamentary language by saying you public servants think like this is your paternal property.
Joseph Matthew.
Sir, good afternoon. My query is, sir, this 95A, before that in 1976, the MHADA Act, there was only 95. That time, sir, the 95 Act was liable to the tenants who are staying in the MHADA properties. Like basically the landowner was also MHADA, the structural owner was also MHADA. After a certain number of years, 1982, the society formation happened and the shift has happened. And in 1998, this MHADA 95 Act has been amended to 95A. Now,
Correct.
95A is amended in 1998.
Yes.
Correct. Now, here the property, the conveyance of the land has been given, is been given to the societies. Now they are the landowners giving the structure. The structure is the society's property. Society means all the tenants of the society.
Correct yourself, Joseph, sir.
Yeah.
It
All
is-
tenants.
It is owned by the people living in the
People
building.
living in the societies. Correct. Now the structural owners are the tenants. Now this Act of 95A should be only liable to people who are staying in the land owned by the MHADA, structure owned by the MHADA.
No, sir.
Correct. Now, if at all they
No.
want to, if at all they want to give, just correct me if I am wrong. If
No,
at all
that's
they
why.
wanted,
That
if
is
at
why
all
I read 95A and I read the preamble for you.
okay. Now,
Okay.
in that case, in that it is very much clearly written. This 95A they should have, this MHADA should take cognizance and get a court order and come to eviction. Basically, they are the landowners. I am the structural owner, so they cannot directly, use their MHADA Act on me.
No, sir.
Second-
Let me just correct you there, Joseph, sir.
Okay, sir.
Okay. That is why I read the preamble. Let me read it again for you. It is hereby declared that this act is for giving effect to the policy of the states towards securing the principles specified in the article. Okay. And what it does is, and the execution of proposals, plans or projects thereof, and the acquisition thereof of the land and buildings and transferring the lands, buildings or tenement therein to needy person and the cooperative societies of occupiers of such land or building. It doesn't say it's MHADA land. If your society has now submitted a proposal to MHADA,
Okay.
saying that we want to go in for redevelopment, the MHADA's job is only to see that your rights are protected till they hand over that property back to you in whatever form the development agreement says, sir.
So they have the right to evict
Yes,
based on this.
because this, if you read this, societies, because MHADA land nowhere says it's only on MHADA land or land belonging to the state. If it was only on MHADA property, see, because MHADA by itself cannot hold property, the state will hold it, na?
Correct.
Correct. So it would have said the building standing on land owned by the state or in the possession of the state. That is not there in the preamble, but it says that societies can approach MHADA.
Okay. Okay.
So it is not barring them.
Further, it is also written unauthorized people. We are not unauthorized people. We are the owners, the original bona fide members. So again, that
No, sir.
point number
In
3.
95A, there is no
95A,
unauthorized mention.
95A, if you come to the point number 3 and 4 also. 3 and 4. Okay.
Yes. See, when you say unauthorized, understand one thing. It doesn't mean that those people who have a legal right to live there. whether you have a legal right to live there will be adjudicated by somebody, no? Like, let me make it very clear to you. Like, you are the landlord. You have given it to a tenant, correct? Now, if the society see now that 70% clause is there, even if you don't agree and your tenant refuses to vacate, he's unauthorized, no? By law, he's unauthorized. Even though he's protected by the Tenancy Protection Act, by law, he's an unauthorized person in that building.
Okay.
Which is
Sir,
going in
again
for
that,
development.
yeah, again that 70% of the tenants approval, correct?
Yes, sir. Yes, sir.
The GR says it's 51% and it is 2034 DCPR rule, it is 51%. But the amendment, they have not yet. Amendment has not been changed or incorporated. If there was some change of 70 to 51%, they would have amended it in the books also.
Correct,
Correct.
I agree with you.
But this MHADA officials are only insisting 51%. So when it is an eviction, you need a 70% approval of the members.
Yes, sir. When you get an eviction notice, that is what you have to write to them. Okay, boss, the GR cannot override the statute. If the statute says 70%, 70% is what has to be followed.
Correct, no? So even in that two matters which you are handling, there is no 70% been given. There is no consent has been submitted. Still, the MHADA has issued a eviction notice. How can they do that? One.
Sir, that is exactly what we challenged today, na? The challenge goes now. See, sir, it is like this. The challenge today, now he can't be evicted for whatever reasons. Correct. When they come, we'll say, where is this? That is why, see, there are certain things, Joseph, of the case we can discuss in an open forum. There are certain things I can't discuss because messages will go back.
Okay, okay.
So my honest submission to you is, let's not discuss this in this forum. I know where you're coming, where you're going. That is why I told you, Joseph Saab, we'll take one day at a time when it comes to the builder.
Okay, okay.
Correct. What did we tell him? आप क्या कर सकते हो और क्या नहीं कर सकते हो, ये दोनों लिख के दो is what we have told him.
So all these statutes which the MHADA has not followed, can we
Joseph sir, we have more
Joseph sir, that is what I'm saying. That will come in on 19th of September. Why are you worried?
Okay, that's what. Yeah.
If you read the application, Joseph sir, 156.3, I'm talking of statutory provisions, no?
Correct.
So I'll go by the statutory provisions. I'll not go by what some officer has decided or some government officers have decided.
So the MHADA officer will not be able to say, "No, I am working in my ambit. That is not my lookout to see whether the rent agreement
is there." He can say anything, but that is what he's saying. I'm saying that is not your ambit. No. Today, how today he's issued a letter saying that agreement has to be there.
So many people will have to follow.
Yeah, when they say, they'll say a lot of things, sir. I also can say I'm the Raja of India. बोलने में क्या जाता है, sir? So it's okay. Let's not go by what they say. We'll go by what's in black and white. Okay.
Anil Krishnan ji.
Hello. Good afternoon, sir.
Good afternoon.
Sorry, I was late little.
No.
In my building, I stay in Ghatkopar Patnagar, 92 building. In my building, there are big problems going on. In fact, in 2006, we have done an agreement with Kumar Builders.
Okay.
And till 2022, he never turned back. What he's doing, what he has means what he'll be doing today. 2022, we decided to go with other builders. We called 4 builders. We had they have given their offers, whatever it was there. Suddenly, the 4 builders, one was Sridham, one was Ashapura, one was Orchid, and 4th was Shubham. Suddenly, everything was going on. Our secretary of the building, he is just BJP Mahamantri. Suddenly, what happened is that he bought Kumar Builders back again, saying that Kumar Builder want to do the project. We said no, we don't want to give him a chance. But forcefully, he bought the builder, and we have done an agreement with Kumar Builder. Now, Kumar Builder is in NCLT. There, everything in Pune Builder, everything has been seized by the police or whatever it is that government is.
By the bankers.
Bankers and everything. Like,
Yeah.
and this one of the director now who is not working them was his name is Shailesh Sundar. What he did is that he said that नहीं मैं आपका बिल्डिंग बना देगा. अरे लेकिन मैं तुम्हारा बिल्डिंग बनाएगा तो ऐसा. We have done an agreement with Kumar Builder, and then Kumar Builder went on when a case or everything was going on, he transferred that our agreement to Haryana Builders.
Yeah.
One Haryana Builders.
Anil sir,
And then
Anil sir,
Hmm.
see, if you keep asking me so many questions, I'll forget.
Hmm.
So
no, I'll
let
just
me
tell you.
Huh.
Okay. Yeah. I'll tell you what the story.
when Kumar Builders defaulted on redeveloping your building, have you sent
Right.
any letter to him?
We have sent a letter and we asked the committee to send the letter where they have not done that.
No, one more, sir.
Yeah.
You have sent the letter, the committee has not sent the letter. So there is no correspondence between the time Kumar Builders were decided till you decide to change the builders. Is there any
Yeah.
correspondence with
No,
him?
no.
Correct.
In fact, in building, in
So-
our meeting also, 1 second, in our meeting also, we asked the secretary that just pass a resolution that we are taking out the Kumar Builders, which they have not done.
Correct, sir. So now who is responsible for all this, sir?
The committee. Or we.
Correct. So file a criminal case on the committee, no, sir. Simple. See, the thing is, if the committee is not thinking about you, why are you thinking about the committee?
No, I went to Pandnagar police station to just file a FIR. What Mr. Kokre told us that अरे आप है ना एक काम करो माडा में जाओ माडा में से है ना वो लेटर दे दो उनको and bring that letter to me and show us, then we will call the committee members and we'll discuss with them.
यानी एक minute. So you mean to say that the Inspector Kokre is a recovery agent?
Yes. Right.
He's not the police.
No, actually he's a now everything has been given to him only, no? Kokre.
No, sir. As of now, my simple question is, when you went to the police station to file the FIR,
he's not taking
he's
that.
nobody. You say कि आपको जो बोलना है मेरे को writing में भेज दो आप. Then let us see whether Mr. Kokre will put pen to paper and send that thing. Okay. I don't go by sir. उसने बोला, इसने बोला. I don't go by that. I said, sir, आप या तो writing में भेजो, नहीं तो आपने नहीं बोला ये. Simple as that, as far as I'm concerned.
Right.
Okay.
And now, and
I do not, sir. I do not go by speculation. I do not give advice based on isne bola, usne bola. No, sir. It is not my cup of tea, and it will not be any advocate's cup of tea.
Right.
That is why I'm asking you specific questions. If your secretary has sent something, you can't do something, file an FIR. FIR is not being filed. Write a letter to the DCP. Sir, when you go to the police station, you're not going to talk to the police to do mandoli.
Right.
You simply go there, give a letter saying that this is the problem in my building and I am filing an FIR. ये सब criminal case हुआ है. इनके ऊपर FIR करना है. You give that letter to him, take an acknowledgement and come home.
Okay.
Wait for 48 hours. At the most 7 days. After that, write to the local DCP. I filed this. I gave this information of criminal offences being committed. They have not acted, so kindly direct them to act and file the FIR.
Okay.
You need to give them 15 days.
Okay.
And then you take it to court. Simple as that. Then they will run, sir. Then there will be lot of tutu mai happening after that.
Right.
अरे मेरे पास आने का, इसके पास जाने का, ऐसा करते थे हम लोग, वैसा करते थे. Everybody will give you suggestions. क्या है ना सर, तट पे खड़ा रह के ना पानी में जो डूबा है उसको बोलना बहुत आसान है. क्योंकि अपना पैर लटक रहा है पानी में. तो पत्थर अपने को ढूंढना पड़ता है. तो तट पे बैठा है उसको नहीं. अगर वो तट पे बैठ के आपकी तरफ रस्सी फेंकेगा ना तो उसकी बात सुनो. अगर वो रस्सी नहीं फेंकता है और खाली बोलता है अरे ये बाजू जा वो बाजू जा, do what is required to be done by law. सर मैं जब बात करता हूँ सर, I go by the documents and I go by what I can decipher from the documents. I don't go beyond anything else. What somebody said, what somebody didn't say, मैं उस पे जाता ही नहीं हूँ सर. My advice when you consult me for advice, sir, my thing is very very clear कि आप document लाओ, ये document में ये flaw है, ये हम लोग ये कर सकते हैं, ये कर सकते हैं, is all I can guide you. उससे ज्यादा मैं नहीं करता हूँ सर।
परवेश कपाड़ी, आपको कुछ पूछना है क्या? आपने अनम्यूट किया अपने आप को।
Yeah, hello.
Yes,
हाँ,
sir.
आवाज सुनाई दे रहा है आपका, पूछिए।
So there is a building in South Mumbai. Last repair was been done by an architect of a amount up to 3,000 per meter of that area of a building, a built-up area.
Okay.
Thereafter, a developer was been introduced, and there were subsequent 2 or 3 estimates made by another architect, and they have made an excess amount ranging over 1 crore. Now the concerned executive engineer has passed a written letter to the tenants saying that if you don't vacate immediately and hand over the possession, so I'll be demolishing the building or demolishing the main part which has to be demolished.
Okay.
Now he has never done 88.3 proposal, neither that was also a C1 category. This thing also issued, but the tenants have taken another opinion and they have got a C2 category certificate. So in that, the tenants have approached to the High Court saying that the estimates have been inflated. But now what is the recourse to them? Because in a day
High
or
Court,
two, the police.
Sir, High Court will not get into the estimates, no sir.
Yeah,
It
but
is-
now who is going to decide whether there is a excess amount to be paid or no? Because of that estimate only, sir, the excess amount has come.
Sir, Kapadia
Yes,
sir,
sir.
I look at it this way. You're saying that to the notice he gave you for demolition is not as per law.
Yes.
166A में criminal case file कर दो ना सर उस पे। देखो
Against
कैसे
the
आता है
executive
भाग के आपके पास।
Against the executive engineer.
Yes, whoever has issued the letter, no sir.
The executive engineer has been issuing the letter saying that you either this thing, you have to vacate the premises now.
Kapadia sir, the cause of action is the letter of the executive engineer, no sir.
Yes, yes. But
So
he has
file.
not issued one letter, he has issued 2 or 3 letters. Thereby the
Sir.
advocate of the tenants have approached the city civil as well as the High Court.
Sir, the thing is, do you have that much time, sir?
No, we don't have the time, but how this thing has to be stopped immediately, because what will
Sir,
happen by
criminal
the
case. No, a public
Okay.
servant does not like a, sir, let me tell you, sir.
Yes,
I
sir.
worked for Air India for 33 years.
Yes, sir.
Okay.
Yes, sir.
And I civilly told them, you all are doing wrong. I filed in the Bombay High Court. I filed in 2013. Can you imagine from 2013 to 2019, nothing happened in the High Court. They said, heavens are not going to fall. Can you imagine endangering of life? The court has told me heavens are not going to fall.
Yeah, in the High Court, I think that
2000, sir, 2016,
on the building.
2016, I filed a criminal case.
Okay.
And now they are running, sir.
So they should take a recourse to the legal criminal this thing.
Yes, sir. 160, sir. Public servant not following the direction of the law. 166 is maintainable.
Okay.
File
This
that.
has to be filed before a magistrate court.
Yes, sir. Why are you filing? You first go to the police station, na, sir. Magistrate will not entertain your application without following 154 and 154.3, na, sir.
But when tomorrow the police suppose it comes, कि बाबा तुम घर छोड़ के बाहर निकलो, घर हमको मांगता है, hand over कर दो माड़ा को. Then what is the recourse
Police,
to them?
sir, police कौन है, sir? Sir, that,
पुलिस ने उनको
sir,
protection देना माड़ा को.
सर आप पहला आप सर कपाड़िया साहब आप पहले एक लेटर तो दे दो टू फाइल दी एफआईआर.
Okay, okay.
फिर सब जन सोचेंगे ना सर. टुडे लेट मी टेल यू दिस वेरी पेटिशंस ग्रुप ना सर, वी हैव बीन फाइलिंग we have been filing RTI applications.
Okay.
We've not been getting information. Today successfully we have filed FIRs on public information officers.
Very nice, very nice.
So sir, that is why I'm saying you have to try. 166A is directly attracted. It protects you in 2 ways. There is no need of sanction when 166A is applied, sir. Criminal manual says that.
Very, very true, very true.
Okay. So just file against the executive engineer, sir. Then you see the fun.
Okay, yes, yes.
Thank you, sir. Sir, मैं civilly बात करना छोड़ दिया, sir.
Yes, yeah, I've seen you this is the first I've been introduced to this thing forum, but I really like this forum and your views and you're taking your things, that way. I really have like to this thing. Thank you,
No, no,
sir.
I appreciate, sir. That is why I said, like somebody said, you're their advocate. I said, I'll talk to you later also.
No,
Because,
I'm
sir,
an architect. I'm an architect and a law graduate.
huh. So,
I'm an architect and a law graduate.
so that is why I said, now just move everything on the criminal side and see, sir, how things will work.
Yeah, I tell the clients. Yeah, definitely,
Yeah.
sir.
Yeah. If they
If there
want
is
advice,
any,
I can give them. That's not a problem.
if there is anyone who wishes to ask any questions, kindly raise your hands up. अगर और कोई कुछ पूछना चाहता है तो अपना हाथ ऊपर उठाइए. If there are no any other questions, then I think Joseph has something to ask. Yes, Joseph, sir.
Sir, one more thing. This resolution, board resolution. Who has to take it? The vice president of MHADA, not anybody else.
Sir. You have to understand one thing. The vice president represents the whole board. Okay. So when the vice president issues that letter, he is issuing it on behalf of the board. There will be a board of directors meeting where this matter would have been discussed and a resolution passed. So that is why, Joseph sir, what did I say? When the eviction notice comes, let him give you a copy of the board resolution and the tenancy agreement.
This too is mandatory.
It's mandatory by law, na, Joseph sir.
Okay.
I have learned from you only. अभी और मेरे को क्या आप क्या कर रहे हो sir?
नहीं, मैं ये बोल रहा हूँ सर कि ये जो है वटकर आज के तारीख में न अपने को कुछ रेजोल्यूशंस बताया है, न अपने को बोर्ड ऑफ डायरेक्टर्स का रेजोल्यूशन भी नहीं बताया, न अपने को एग्रीमेंट का. वो बोलता है दैट इज नॉट माय लुकआउट. सो ये ऑफिसर
बाकी दो मैटर में भी वो वही बोला ना.
या
करेक्ट. तो वही, because by law, Joseph sir, let me tell you one thing. Under the law of equity, what applies to those two will apply to every tenant in Pantnagar today.
Agree.
Okay. Attach that and say, boss, the court has said that you have to follow the law. So you give me a copy of the board of directors and the rent agreement. Failing which, I will initiate criminal action against you करके लिख के दे दो ना सर उसको. 4 लाइन लिखने में अपने को खर्चा नहीं होता ना जोसेफ सर.
Okay.
So then do it that way ना.
Thank you.
I mean,
sir, I have a small
STM.
suggestion. Yes, sorry. I have a small suggestion, sir. Can you make a WhatsApp group and keep in touch? And if you already have a WhatsApp group, can you please add me to that WhatsApp group? I will
sir,
send my phone number.
you have to talk to Joseph sir. He's the boss. I'm just a slave in his group.
Nothing of that sort. It is,
Sir.
we have already a group. We can add it to him in the group.
We have a group called redevelopment group. So in that he can add you.
I'll put my number in the chat. Please add me to the group. Thank you so much, Joseph.
Welcome, sir.
God.
Now, anybody else?
I think Manish Bhai wants to ask something.
I have filed a declaration suit in the small cause wherein I have entered into a consent term with the developer, he is also the landlord, wherein he has agreed to pay me rent of rupees 50,000 till I am put into petition. For 2 years, he made the payment regular. Now we stop payment for the last 3 years. Now, what is the remedy left before me, sir?
Sir, Justice Katawala's order is there, no, sir. It is, sir, that is what I'm saying. Now, let me also complete. The Honorable Supreme Court, even as on 5th August, 22nd July, has clearly said that even if it is a civil agreement, if there's an element of cheating, a criminal case is maintainable.
So you file a criminal
yes,
suit recovery of rent.
Yes, sir. Yes, sir.
Okay, sir. Thank you.
If there are no other questions, then we can conclude. Gaurang Bhai.
All right. Since there are no more questions, we'll wind up this wonderful session we had today, webinar. Thanks to the speaker. Firstly, thanks to the speaker, Mr. K.V.J. Rao, for patiently listening to all our queries though at times it might be irritable, but then, thanks to your patience that you answered them, each and every one of them. And though some people are writing on the message that they joined in late and they read the link and all that, I'll give you the number. You can, get in touch with that person and we'll send you the link if you're not a part of the petition group. So thanks to Mr. Rao, thanks to Mr. Joseph Matthew for, raising this issue of Section 95A. Section 95A, so that more people benefited from that, and more people will start getting activated rather than taking it lying down by the builder and the MHADA officials. So now they'll start raising their voices, and I hope that they get justice in future in their redevelopment projects. So thank you everyone who has been part of this webinar today, for finding time, 2 hours of your Sunday time. And another thing is, I'll give a little background about petition group, which has convened this webinar. We are a group of activists and concerned citizens based in Mumbai, but there are members from all over India who are, we support each other, we guide each other, exchange our, expertise, and take it collectively with the authorities. And whenever the government also, we find lapses in the policies, implementation of policies or improper laws, we communicate to them our displeasure and try to modify it. So that's how our petition group works, supporting each other and communicating with the authorities to bring about a change for the better. And our website, as you all must have read in between, website is www.petitiongroup.com. So you may go on to it. People who wish to join, or expressed wish during the webinar to join, can go on to it. There's a tab for join WhatsApp, PG WhatsApp group. You may click on that and fill up the form. We'll add you. And there are some people who are messaging just now that they wish to be a part of the redevelopment group. In that case, Mr. Joseph, kindly give your number if you don't mind. If you're admin of the redevelopment group, kindly give your number just now.
Yeah, I will give.
Say it.
Joe, right now.
95.
So I already put it on chat. I mean, if anyone wants, they can take it also.
997891. Correct.
Speak softly. Joseph, slowly bolo jara fir se.
9594997891.
वंडरफुल. हाँ, तो सभी ने नोट किया होगा. तो इसके ऊपर आप, अगर आपको ये रीडेवलपमेंट ग्रुप में ज्वाइन होना हो व्हाट्सएप ग्रुप पर, तो एडमिन का नंबर अभी जोसेफ जी ने दिया है खुद का, तो उनको मैसेज कीजिए, व्हाट्सएप कीजिए कि भाई आपको ज्वाइन होना है, थोड़ा बैकग्राउंड दीजिए आपका, तो वो जरूर ऐड करेंगे आपको. और भी कोई क्वेरीज हो पेटिशन ग्रुप के बारे में, या आप चाहते हो कि और कोई हम वेबिनार रखें फ्यूचर में कोई लॉ पॉइंट के ऊपर, तो मैं आपको नंबर देता हूं हमारे कोऑर्डिनेटर का. आप उनसे संपर्क करें व्हाट्सएप पर. पहले तो व्हाट्सएप पर करिए, वो जरूर आपसे रिवर्ट बैक करेंगे. उनका नाम है मिस्टर नीरज पटक, जो हमारे आज के वेबिनार के होस्ट भी थे वो. तो उनका नंबर है 9769767969. स्क्रीन पे भी है. रिपीट करता हूं मैं, नीरज नाम है उनका, 9769767969. तो उनको व्हाट्सएप से संपर्क करें. हम अब जरूर आपको गाइड कर सकेंगे कि व्हाट्सएप अपने वेबिनार फ्यूचर में कैसे करना है, या ज्वाइन करना है, या जो भी और कोई हमारे ग्रुप के बारे में जानना हो, तो जरूर उनको व्हाट्सएप करके आप संपर्क कर सकते हैं. और मिस्टर राव जी, आपका भी जो नंबर आपने तो 1-2 बार दिया है, मैं फिर से दे दूं मिस्टर राव?
Yeah, please. 97.
हाँ.
9769 909 787. Neeraj, I think this lady is coming late there. She wants to ask something.
So Shamim ready?
जल्दी ले लो तो फिर नीरज. हाँ.
She needs to unmute from her end.
Yes, ma'am.
She
Come in,
doesn't know
madam.
to
We can hear you. If you want to ask something, then you can.
Okay, Neeraj, perhaps she doesn't know how to operate this. Let's wind up now. Thank you very much. मिलते हैं फिर कभी. Thank you so much.
Thank you. Thank you, everybody.
Thank you, Rao sir.
Yeah, welcome. Bye.